Well, hello everybody and welcome. My name is Jason Harris, and I see there's people signing on, and so we can go ahead and get started. This is the estate planning presentation part of the Dakota Works Group. I just wanted to tell you a little bit about myself before we dive into this. I've been at Dakota Bank now for about 4 years. I'm part of the Trust and Wealth Management Department. Prior to that, I taught law at Augustana and Sioux Falls, and I practiced law prior to that for about 13 years in Sioux Falls and in Canton. Got a lot of experience working with estate planning and particularly with individuals and families. Couple things before we get started. I do want to just let everybody know that this presentation is for educational purposes. We aren't providing any legal advice during this. We're just trying to give you an overview of what estate planning is. The other thing is our department is not in the business of estate planning. We do talk with some clients and give them some ideas, but the most appropriate place to have an estate planning conversation is with an attorney that is licensed in the state where you live. From a technical standpoint, we do have some tools. I think most people are familiar with the tools that we have available to us through Teams. You'll see on the top of your screen, you should see several tools. That one would be chat. We do have somebody monitoring the chat. I won't be monitoring the chat because I'll be giving the presentation. But if you do have a question that comes up, you can type that into the chat. We will be I'm hoping to get time at the end for questions and answers, and you can ask them at that time. If I speak too fast, which many of my students used to complain that I do, go ahead and raise your hand, and I might catch that out of the side of my eye. Or if you want to do a react button. So one is you can put chat and then type your message in. The other is raise your hand if I'm going too fast. And then the last one is you can react if you think, something that you agreed with, or there will be a couple of times where I ask you to interact. So with that, let's go ahead and get started with the presentation. This is kind of the roadmap of where we're going to go. Number one, we want to talk about what is estate planning. Number two, we want to talk about why it matters. Three, we want to talk about key documents. Then we want to end by talking about common mistakes people make in estate planning, give you some practical tips, so something you can take away with, something that you can do today, next week, and next month to put your estate plan in place, and then see if you have any questions and answers, or if you have any questions, and then hopefully I can provide the answers to those. The short answer to every question is anyone owning property needs an estate plan. You'll hear me say that several times throughout today's presentation. I want to begin with a story. Most of us have heard of the rock star Prince. I titled this story Purple Pain. It could also be what the feeling is. I'm a Vikings fan, so that exists. It was almost 10 years ago today that Prince died unexpectedly. He died on April 21st, 2016. And he also died unexpectedly without a will, or without a trust, or without an estate plan. Now, you would think that somebody as famous as Prince, with as many assets as Prince had, that he would have some sort of estate plan, but he did not. And then I want you to fast forward to 6 years later, in August of 22. That's when a judge finally approved the final distribution plan for Prince's estate. So it took 6 years from the time he died to the time that the court said, here's who gets the assets, here's how the assets are going to be distributed. Now, I want to add a footnote to this that was not available at the time I put this together. Last week, I was in Minneapolis meeting with an attorney, and I was telling him about this presentation. And the attorney was like, oh, well, our law firm worked on the estate, and it's still going on. So we are 10 years on, and the Prince estate is still going on, and it's largely going on because he didn't do any estate planning. So why does this matter, and what were they fighting about? Well, I'm going to give you some facts about the Prince estate. The final valuation of the Prince estate was $156.4 million. That's actually a nice, tidy little sum. I would have thought it would be more, but it's still pretty good. The initial amount that the personal representative that they said the estate was worth was 82 million. Why does any of this matter? Because the IRS got involved. Any estate under current law, and again, it was different in 2016, any estate over 15 million is subject to federal estate tax. That tax ends up being, roughly about 40% of the amount above that. I did some rough calculations, and so if the estate had been valued at 82 million, that only would have been about 32 million in tax versus 62 million in tax at the 156. Now that may not actually be the tax amount that was paid. That's just some rough estimates. But if people go, well, why were they fighting on what the value? They fight on what the value is mostly because of the taxes. I was unable to find how much it cost to do what the attorney's fees were. My estimates, based on stories I've heard, my experience and all of that, is that it probably was in the neighborhood of 25 to 30 million in attorney's fees across it all. So first thing is they were fighting about the valuation of the estate for tax purposes, both the estate tax and also for income tax. And then the other thing that they were fighting about is who were the heirs. He didn't have a will, he didn't have a spouse, he didn't have children. So then who are the heirs? And that is determined by state laws. And ultimately it was determined there were 6 heirs. He had a sister and he had 5 half siblings. And throughout all of this, some of the half siblings, I think it was the half siblings that did this, what they did is they actually sold their right to receive distribution, which made things even worse and diluted it. So that's probably going a little bit deeper than we need to, but it's a little bit on the facts. So what's the takeaway from Prince? Prince's estate shows how no plan means more costs, more conflict, and less control. Prince could have avoided almost all of his problems with a will, a trust, and a clear succession documents. Now the question becomes, why didn't Prince do it? I don't know why Prince didn't do it. I know why a lot of people don't do it, and that is they procrastinate. And I'll talk about that towards the end. Now I do want to do a quick poll to make sure that everybody's paying attention. And I want to ask, how many of you have an estate plan? So we'll take a couple of seconds. Hopefully the poll launches up, and go ahead and submit your answers there. All right, it looks like most people have answered, and I am going to close the poll. For those that want to know, 70% of you do not have an estate plan in place. That's really not surprising. That's really kind of in accordance with what we see across the country. But the fact of the matter is we'll talk about it here in a second, every one of you needs an estate plan. So what is an estate? Okay. An estate is everything that you own. It's a home, it's bank accounts, it's investments, insurance policies, IRAs, 401k. If you've got a 401k with Dakota Bank, you have something that would be subject to an estate plan, and you need to be aware of that. Real estate, collectibles. Maybe you've got a set of baseball cards sitting in your basement, and you've got to figure out who's going to do that. Anyone owning property of any kind needs some sort of an estate plan. It might not be a will, it might not be a trust, it might be some alternative thing to avoid probate, but everybody needs an estate plan. Okay. Why is it important? Well, we saw in the Prince case that it's been 10 years since he passed, and there's still ongoing litigation involving his. So one is to protect your loved ones. It's to protect them from ongoing litigation. It's to protect them from disputes. It's to protect them from all of the problems that can be there. If you've ever lost a loved one, and I've lost both my parents, one of the things that happens is there is an incredible amount of grief. And then when you add on top of that incredible amount of grief, a whole bunch of things that you have to do, that can cause all sorts of tensions in family. I've seen it in my family, and I've seen it in families that I've represented. So if you have an estate plan, you can protect your loved ones and you can prevent disputes. You can also avoid probate. Probate is the legal court process that had to happen in the Prince case. It's public record. You can go down to the courthouse and find out who's represented by whom and certain public filings. But the other part of it is it involves lawyers' fees, and it's very, very expensive. In some cases, estate planning can minimize your taxes. For most people, and by most people, I mean people with less than $3 million, this isn't going to be a big deal, okay? But some people, it is a problem, and they want to try to minimize those taxes. But estate planning, not only does it affect things once you pass, it affects things while you're living. And so you may want to enforce or outline what your healthcare wishes. And we will talk about each one of those before we are done here today. And I got to make sure I'm on time. I'm going to make sure that we get through. So when I was teaching, one of the things that we always had to do is law is kind of like a foreign language. And so we have to make sure that people understand what some of the key terms are. And I'm going to go over these fairly quickly. And I believe that the PowerPoint will be available to the viewers on DakotaNet. And so you can come back and refer to these. But we do need to make sure that we understand what some of these key terms are. And so I begin with the first one, which is the testator and the grantor. And these two things deal with, if it's a will, a testator is the person creating the will, a grantor is the person creating a trust. The beneficiary, this is what we all want to be. This is the person who receives the assets, either through the will or through the trust. If somebody dies in a will, you're going to appoint what's called a personal representative. This is the person who is the CEO, the manager of the estate, and this power kicks in after death. The trustee, this is actually what we do here at Dakota Bank Trust and Wealth. We are appointed as trustee for various trusts. We are the ones who manage the assets of the trusts. We also make distribution requests. We're the CEO, as it were, of the trust. Guardian, and I probably should have conservator up there as well. If you have children under the age of 18 and something happens to you and you pass away, who's going to take care of your children? Well, a legal guardian is going to need to be appointed, and these are the people that will care for the minor children. A conservator is the financial side of that. Probate, we've talked about that. That's a court process of validating a will and then distributing the assets. And intestate, Prince died intestate. In other words, he died without a valid will. It's a funny little word, but it's nonetheless a word that we use in the law. Other fun words that we use are things like revocable and irrevocable. Revocable means that, and generally these apply to trusts, it means that it can be changed or canceled during your lifetime. If it's irrevocable, it cannot be changed or canceled during the lifetime. A fiduciary, this is the role that we serve here at Dakota Bank Trust and Wealth. We are the people with the legal duty to act in another's best interest. It applies to the trustee, and it also applies in a power of attorney situation that we'll be talking about later. So in other words, as the trustee, all the decisions that we make have to be in the best interest of the trust, of the beneficiaries, and can't be in, for instance, my own best interest or in the best interest of Dakota Bank. Durable. We'll talk about this term when we talk about power of attorney. You want your power of attorney to be a durable power of attorney. In other words, one that remains effective during incapacity. So now we move into what is estate planning. We talked about what's included in an estate. We talked about who needs it. So what does estate planning include? It includes planning for things that happen both while you're alive, but also after you pass. So it includes asset distribution plans. Who do you want to get that baseball card collection? Who do you want to get whatever money is in your bank account? Who do you want to receive or get the money that is in your IRA? It also involves healthcare decision making. if you're at a point, and I'll talk about this a little bit, most of the stories I tell, by the way, are about me and my own family, because that's where I've learned the most about estate planning. What happens if you're incapacitated, whether it's a long term or a short term? I had a fall back in January where I slipped on the ice and lost consciousness for a little while. Well, who's going to make healthcare decisions for me at that time? And that can be determined by a power of attorney. Also, who's going to manage the money if you're incapacitated? Maybe something happens. My mother, towards the end of her life, had Parkinson's disease and dementia that came along with it, and she really could not manage her life or her healthcare decisions. I was appointed as the power of attorney and had to make those decisions for her. Estate planning also involves tax minimization strategies. It also involves appointing guardians and conservator for minor children, but also involves business succession plan. That's where it is applicable to a lot of our customers. If they have a business, what's going to happen if they pass on? Everyone needs a basic estate plan. So why is it critical? Now, when we first put this PowerPoint together, I put together the words. I did not put the graphics in or the photos, and I was actually a little upset about handcuffs, because there's nothing criminal about estate planning, but I actually like it now, because without estate planning, you basically handcuff those that are left, and you handcuff and you put their hands behind their back and say, now build a bike. Okay. You don't give them the tools that they need to, and you take away their ability to do it. So without an estate plan, state laws determine asset distribution, and that may not matter to most people, but particularly if you have a blended family or if you have other family problems, you may not want the state and the laws of the state to determine what happens. If you don't have anything, courts get to choose the guardians for your children. And it might be that brother or sister that you just don't like. Okay. I have a good friend of mine. He's one of, I think, 8 children. And the thing is the family is actually split in half, the children. 4 conservative, 4 liberal, 4 like each other, 4 don't like each other. Well, the court is going to look at any one of those 4 for a guardian for a minor children. They might choose the person that you don't want. Why is it critical? Family disputes and lengthy probate. Family begin fighting when there is no plan in place, and probate, at a minimum, even when things go well, takes a minimum of a year. Okay. There might be unnecessary taxes and legal fees. Like I said, in the Prince case, I estimate the legal fees to be in the neighborhood of $30 million. And then while you're living, if you don't have an estate plan, there's nobody to control, and you won't be able to, because you're incapacitated, make any financial or medical decisions. So now we turn into the core documents of an estate plan. And I basically already said these before, but I'm going to go over them again, and then we'll talk about each one of them as we move through the presentation. The core documents include a will or a trust, or in some cases, both. It includes powers of attorney, both for financial decisions and medical decisions. It includes what we call an advanced healthcare directive. Some people call it a living will. It includes beneficiary designations, guardian nominations, and business succession documents, if that's applicable to your situation. So now I want to do another poll question. And I've talked about this, and I've mentioned it a couple of times. Who do you think decides what happens to your assets if you die without a will? And I'm only going to do South Dakota. So pick which answer you think is the best answer. It's either Robert Foberg, South Dakota Governor, United States Supreme Court, or South Dakota law in the court system. I've seen quite a few responses, and the good news is it appears that people are listening. And it also appears Robert Foberg's not on the call, because nobody has voted for Robert Foberg. Everybody chose the right answer. The correct answer is South Dakota law. So what happens under South Dakota law? Okay, under South Dakota law, I thought I had a slide. Under South Dakota law, What happens is if you're married, everything goes to your spouse, unless you have children from a previous marriage. If you have children from a previous marriage, your spouse gets the first $100,000, and then the remainder is split between your spouse and your children from a previous marriage. Okay. So that's what happens, and that's why we have so many blended families, and it could impact it. I'm a blended family. My wife has a child from a previous marriage. We have a child together. Without that will, if my wife were to die, I would get some, but also some would go to my stepson, which frankly would be perfectly fine. But the way that my wife and I look at it, we look at it as we have two children. So we're going to talk first real quickly about what documents you have to take care of things when you die. The first one is the last will and testament. It's a legal document detailing an individual's wishes regarding assets and dependents after their death. You designate a personal representative. You remember the CEO of the estate. You outline the wishes for how your property is to be distributed. It could be as simple as I give everything to my spouse, and if she dies before me, then everything goes equally to my children. It can be as specific as I want my wife to have, all of the furniture, the property, the house, but I want my boys to have the tools and the gun and a specific car and things along those lines. You also, in many wills, is when you name a guardian and a conservator for your children. Now, wills are good tools, and I recommend, honestly, that everybody has a will, but wills need to be probated and they need to go through the court process. And there's alternatives to a will, and this is where you want to try to avoid this probate. And there's several ways to do it. And I'm not going to describe each one, but one is bankers hopefully are familiar about designated beneficiaries on eligible accounts, whether it's your 401k where you've designated a beneficiary, whether you've done a payable on death on a CD, whether you've named a successor on a CD, if you've got jointly owned property, whether it's a bank account or whether it's real estate, those things can happen a little more automatically. That you can give money away during your lifetime. You can have a deed that's transferred on death. You can do what's called a life estate. In other words, you might transfer property to somebody, but you reserve a life estate. In other words, you get to use it for the rest of your life. You might create a trust, and it might be an irrevocable trust, or it might be a revocable trust. So what are the advantages of trusts? A lot of people talk about trusts. I really like trusts. Are trusts for everybody? Not necessarily, but what are the advantages? Number one advantage of trust is it avoids probate, because a trust doesn't die. A trust exists for however long the trust says it exists for. And again, you've got a CEO of it, which is the trustee. And if it's a human being and that person dies, there should be a successor named. If it's a corporate trustee like Dakota Bank, we continue to manage it. The other thing that's really nice about trusts, particularly in South Dakota, is the privacy aspect. It's its own being. You can't have people going down to the courthouse to find out what's going on in a trust. And that can become very important, especially for wealthy families, but for many of us. We don't want everybody knowing what we're fighting about. Another advantage of trust is minimal attorney's fees at the time of death. There are more fees to set up a trust, and I'll talk about that before we end here. But at the time of death, there really aren't very many attorney's fees because everything's already been outlined, and it leads to a smoother transitions of the assets to the beneficiaries, and you don't need to go get court approval for everything. The other thing is the trusts allow, and some parents like this and some parents don't, is it allow, or beneficiaries, excuse me, is it allows the grantor to keep what I call strings attached. If you have a will, and if you give everything to your spouse and then to your children, if your children are under the age of 18, and your spouse dies before you, your children will get it into an account, but once they turn 18, they have access to it. So I think of a trust that we just recently onboarded an individual. Unfortunately, his father passed away, and when he was 16, But luckily, his father put the money into a trust, and he can't access the money in full until he's 25. Once he reaches 25, then he can get it. But can you imagine a 16-year-old getting $750,000 and what decisions they might make? I've had two 16-year-old sons. I taught college for 16 years, and I'm just telling you that the male between 16 and 22, that is not the peak of their decision-making ability, and I mean that in the most kindest way. Most of your trusts that we talk about are living or revocable living trusts, but there might be a need for irrevocable trusts. I'm going to highlight really quickly just three that might apply to many of the people on this presentation. One is a special needs trust. I have two brothers that are significantly disabled. One has since passed, but they both were born with what is called trisomy 9. In other words, they got three sets of DNA, and so they functioned at about the 10 or 11-month level. And they are on government assistance. They live in a group home. They need 24-hour care supervision. You might want to set up a special trust, special needs trust for them, because when you're on government assistance in that kind of a case, you can only have 2,000. In South Dakota, you can only have $2,000 of cash and only $2,000 of assets. Well, they might have other needs. And so you can set up trusts that allow to provide for those other needs that don't disqualify them from the governmental assistance. The second kind of irrevocable trust that you can do, and this is highly technical and requires lawyers and years of planning, is a Medicaid trust. And this is primarily for elderly people that as we age, my mother-in-law and my father-in-law are an example. My father-in-law is in assisted living. My mother-in-law is not. And so as they're doing that, that's obviously very expensive. And one of the things that would be a possibility is as they run out of money, does my mother-in-law get to stay in the house? If a Medicaid trust was set up, there are ways to protect those assets so that they can still receive that Medicaid assistance if they need to. And then the last one is the Spendthrift Trust, which basically protects individuals. You put the money in the trustee determines how much goes out. And if the individual goes and racks up their credit cards, the credit card companies can't come in and grab those assets. And so they really kind of protect the assets. So I'm going to move to my last poll question, if it pops up here. And my last poll question is, I'm going to ask you, so remember earlier we said 75% or so of you guys, I think it was, the final number was 72% of you said you don't have an estate plan. This is a little bit more refined. What percentage of Americans have a will and or a trust? And it's one of these numbers. All right. So it looks like most people have voted. There's still a few votes. About 36%, 31% of you said 15%, 36 of you said 25%, 31 of you said 31% said 35%, and two of you said 2% said 45%. And those of you that said 25% would be correct based on the polls that I've and the numbers that I've seen. Every one of them are a little bit different. And I see that there's a couple of questions in the comments, and I'll try to address those at the end if I get a chance to if hopefully if I can get to them. So we've talked up to this point about what happens while we're alive or once we die. Now we need to talk about planning for that incapacity. I told you about my mother. My mother, towards the end of her life, she had Parkinson's disease. She had dementia. When I was teaching, I used to tell the story about she used to write. She literally would write a check on a piece of notebook paper, and she'd pay to the order of and write a number down. And so she couldn't manage her financial affairs. Luckily, we had taken some steps in this, and I had been appointed power of attorney. of her. And I used to draft these for a lot of different clients. And so the durable power of attorney for finance is an incredibly important document. And I know a lot of the bankers here see these documents and they look at it from a different lens, is do they have the power and things along those lines. But I want people to understand how good these documents can be and how helpful they can be. First of all, they do grant authority over financial decisions. You're appointing somebody to make decisions on your behalf. And they can be either immediate or they can be what's called springing. And in a springing durable power of attorney for finance, it doesn't take effect until the person is incapacitated. When I drafted them, I like the immediate, because with the springing, you have to go to a doctor usually and you have to go get a note that they're incapacitated and those kinds of things. So I always like the immediate, but some lawyers like the springing, and there might be cases for it to be springing. You need to talk through that with your attorney. All of them should be durable, though, that no matter whatever kind it is, that it survives incapacity. And probably the most important thing is to choose a trustworthy, financially responsible person to be your agent. In my case, I've chosen my spouse. And then the backup actually is my mother-in-law, and we need to revise our documents because when we had originally written them, both of our children were under the age of 18. I now feel comfortable enough that with at least one of my children, and I'm not going to tell you which one it is, to make the decision. What you generally see in families is it's generally the older one. The oldest child is the one that takes that on, but it could be a trusted friend. It could be anybody along those lines. Other documents for incapacity are the healthcare or the medical power of attorney. These tend not to be immediate. They tend to be a springing, but it does, again, designate someone to make the medical decision. The reason these are generally a springing is you're generally in the hospital and there's a medical professional that can already make the determination that they're unable to make these decisions. And it's active only during the incapacity. And again, you want to choose somebody who understands your values. You do want to name alternative agents because things happen. And you want to provide copies of these to your healthcare providers. The last thing is the living will, or the advanced healthcare directive. This specifies the kind of end-of-life treatment preferences that you might have. It addresses life-sustaining treatment, pain management, and organ donation. You're not supposed to describe it this way, but it's kind of you telling your family when you want the plug pulled. In other words, if you're on life support, when do you want that to happen? And it's really in many ways kind of a gift because the family doesn't have to make the decision now. You've already made it. And these are things that you should be discussing with your spouse. If you have adult children, you might want to be discussing. If you're part of a sandwich generation, should be discussing these with your parents. That's basically the documents you need. That's basically the things you need to consider. Here are the common mistakes that people have. And the first one is the most common. It's procrastination or not doing anything. I sat down with somebody a couple of years ago and I said, well, what is your plan? And he looked at me deadpan. I plan to live forever. And I'm like, well, that's a good plan, except that nobody in the history of the world has ever succeeded that. Everybody that has ever been born. So when we look at this, we've got 72% of you have no plan, but 100% of you are going to die. That's the one thing that we know in life. But yet we procrastinate. Why? Number one, it's usually not, frankly, top of mind or it's important. We don't want to sit around thinking about what's going to happen and when we're going to die. But I'm here to tell you that based on what happened to me back in January where I slipped, I fell, I hit my head on the ice, knocked myself out for a little while. Luckily, my dog was there. Not really luckily, because she's still mad about not being able to go on the walk that day. But it very quickly could have ended. Nothing serious happened. No bones were broken. No brain bleeds or anything like that. But we do hear stories of this happening. Okay. A second common mistake that I see, and it's only going to get worse with AI, are do-it-yourself documents. So you used to be able to go to the office supply store and get powers of attorney and wills, and they're pretty good. Now you could get them on LegalZoom. Well, now what you can do is you can just ask ChatGPT to draw one up. And frankly, I have done that, and they're not bad. But part of it is lawyers know what is good in them, what isn't good in them. Lawyers know how to execute them so they're properly executed. I would avoid do-it-yourself documents, but they can be tools to help you begin the discussion. Outdated documents. I already mentioned my powers of attorney are already outdated. The powers of attorney that my wife and I have on each other actually have her mother's power of attorney. Her mother's 84. Maybe it's time to think of somebody else to do that. My father was the best example of outdated documents. About 16, 17 years before he died, he did a will. And then he didn't do anything. There were a lot of tax law changes. There were a lot of changes in our life. We were able to make things work, but you really should be updating your documents. And I'll tell you this a little later, in probably about every 3 to 5 years. If you create a trust, fund it. Some people go to their lawyers, they spend a whole bunch of money to get these things funded or created, and then they don't put anything in it. And that's a problem. Poor agent selection. Maybe you choose somebody to be your power of attorney, and they either do it, they don't do it at all, or they do it not the way you want. Lack of communication is a problem. If you create a plan, tell people that you've created the plan. You don't have to tell them what the plan is, but tell them that you've created it and tell them where they can find it. And then the other thing is forgetting an asset. That's why you need to revisit these things every so often, because maybe you've acquired a new asset and it wasn't included. So I want everybody now to put in the chat one step that you could take today to start your estate plan before I tell you what I think things you can do. So just start putting in the chat. Just go ahead and type in there and light it up. I've got make a list of assets, update my will, talk to a pro, update will, designate beneficiaries, research good attorneys, update will, make list of assets, go to see a lawyer, find an attorney. Don't continue to procrastinate. I like that one. Review the documents I've started. I have it made. I need to save it with the bank and doctor and ensure family has copies. All of those are amazing answers. Here are 4 things that I think you need to do to get started. Inventory your assets. Create your own personal financial statement. Define what your goals are. What is it that you want to happen when you pass away? Choose a trusted agent and consult an attorney. Those are the 4 things that you could do. When do you review your estate plan? You review your estate plan anytime you have a major life event. A major life event is a birth, death, divorce, marriage, change in your finances. Maybe you lost your job. Maybe you won the Powerball. I'd love it if you did that. Maybe there's been a tax law change. We just had a major tax law change last summer in the one big beautiful bill or whatever it's called. If you move to another state, different states have different rules. If there's been a change in your health, and at a minimum, review it every 3 to 5 years. And you particularly want to put together a estate plan if any of these 3 things apply to you. If you have blended families, and I'm really, frankly, looking at this picture and wondering who picked this, because I don't think blended families means a middle-aged couple with cows. I think it means people with prior marriages that bring kids in, kids from prior marriages, but I'll leave that where it is. Maybe they're business owners, or maybe they're high net worth individuals. Those 3 cases definitely need to talk. So I like to give a checklist, okay? Here's a checklist of 3 things, 3 different time frames. One is immediate things you can do this week. The next is something that you can do over the next month. And then the last one are the ongoing. If you complete an asset and a debt inventory, which you should be doing anyway, then that's something that you can do. What's everything that I own? What bank is it in? What's the account number? Who are the beneficiaries? Identify potential fiduciaries. Who could take over for this if we wanted them to? Research estate planning attorneys. This is one area where our department can help. We do work with estate planning attorneys throughout the region. Schedule an initial consultation. Those are 4 things you can do this week. Then this month, so after you schedule it, then you meet with the attorney. You gather the documents that the attorney has asked you to gather. You make these fiduciary decisions. Who's going to be your power of attorney? You begin the drafting process. And then the ongoing is review the plan every 3 to 5 years, update after major life changes, keep the documents secure but accessible. And then the last one's really, really important. Communicate with your family that you have a plan. If you trust your family, and every family's different, you may even want to communicate what the plan is. Ideally, in my opinion, everybody would be in the same room when this happens. That's really all I have. I did have some information previously about cost, and people ask about cost. It's really going to vary based on where you're at. Generally speaking, a will is going to cost you between anywhere from $800 to $1,500 for a married couple. Trusts are going to be about double that and up, depending on how complicated they are. When you do the will, you're generally going to get your powers of attorney with that. So with that, I know that there's been some questions. I'm going to scroll through and just see if there's been any. Somebody had asked, what's the limit for the small estate probate in South Dakota? I believe it's $100,000, but that one I can't remember. I think they changed it. It used to be 50, but I think it's $100,000. Somebody asked, do designated beneficiaries trump designations in a will? Do designated beneficiaries trump designations in a will or vice versa if the documents do not agree? If you have if you have a 401k and you designate a beneficiary, that will trump anything that's in the will. So any advice for how to talk to relatives about creating their will or trust? Yeah. Part of it depends. It depends on your family. It's a hard conversation to have because again, most people don't want to talk to it. If any of you have ever experienced a loved one dying, and I think of the first ones that died that we experienced would have been my grandma and grandpa, and they had lived through the Depression, and we had to go in and clean their house. And if any of you had a relative that lived through the Depression and then died, they saved everything. My grandfather had baby food jars of nails and tacks and screws and all those things because you might need them someday. I think the thing is that you want to begin the conversation by saying, do you have an estate plan in place? Do you have a will in place? What happens with this stuff? And if you can get them talking about it, then oftentimes you can then get them to a lawyer. No, somebody said, can I use online template or AI? No, I would recommend against it. There's too many pitfalls. It leaves too many things out. And there are, especially with a will, there are execution things that you have to do. So I'm showing that we have 1 minute left, and I'm not seeing any more questions. So without any other questions, I'm going to thank everybody for spending some time, and I hope everybody has a good Friday.